Shortbread. Good morning, good afternoon, good evening. We are going to be going over some DeCastro stuff today. And here, we're going to do like this. All right. So we're going to start off with DeCastro versus Abrams. The court finally got off from sitting off of it on its hands and decided to basically wash its hands of the case. Now, everybody already knows. I'm not letting anything out of the bag. Everybody already knows that everybody's motions for everything were granted, except, well, basically all the claims were dismissed. So the cross complaints were dismissed. The complaint was dismissed. The motion for contempt was denied. The court just went, you know what? I'm done with this nonsense. Peace out. Now, I don't want to waste a lot of time. I'm sure other channels have gone over reading these things. My big takeaway from this is that there is an issue that the court does not state how things are dismissed. You know what? Let me just check one thing while I'm doing this. There's one thing I didn't see, and I want to see it. And that's DeCastro, wrong DeCastro. There. I wonder if there is an order. There is an order dismissing case. Let's see what that one says. Yeah. So the case was dismissed. Now the problem here, as I see it, is that the court does not give any indication on whether or not this case has been dismissed, whether the complaint has been dismissed, whether the cross complaint has been dismissed with prejudice or without prejudice. Now, I'm sure most of you know what that means, but for those of you who don't, with prejudice means that you can never, ever, ever bring that cause of action back in the same court. So if Chili's complaint for copyright, if his complaint for copyright for those videos against Kate was dismissed with prejudice, then he can never, ever, ever sue her in federal court again over the copyright infringement that he alleges that she did in this complaint. If it's dismissed without prejudice, that means he could bring it again. So what that means is, like, basically the court's just saying, you effed up this time, but you can refile. You can refile. You can correct your mistakes and make things better. So what a lot of the decision turns on, at least in the motion to dismiss Chili's complaint for copyright, is this Cortez Ramos versus Martin Morales. Now, in Cortez Ramos versus Martin Morales, it went up to the First Circuit Court of Appeals, and the First Circuit Court of Appeals is controlling over Massachusetts. Massachusetts is within the First Circuit, so the First Circuit Court of Appeals decision is going to be binding on the District Court of Massachusetts. I swear to God, they hear me sitting back here talking, and they want to come back and hang out. So one of the things that was decided in Cortez Ramos versus Martin Morales, two issues went up. The district court had dismissed the complaint for copyright with prejudice, and there are two issues that were brought up. One is, can the plaintiff amend his complaint to fix the late filing issue? And the First Circuit Court of Appeals decided, no, you can't amend your complaint to fix the registering it after the complaint's been filed issue. That's a jurisdictional requirement. The court can't hear it unless you have actually registered your copyright prior to filing your complaint. So that was one of the issues. The other issue that the court had to deal with in Cortez Ramos versus Martin Morales is, did the district court, was it correct for the district court to dismiss it with prejudice? And the First Circuit Court of Appeals said in there that the complaint, it could be fixed by refiling it. Now that the copyright has been registered, now if the plaintiff refiles, then he's good. He's met the registration requirement. So I know it seems like an extra step, a bit of nonsense, a waste of time to not just allow him to amend his complaint and to require the case to be dismissed, and then he has to refile it. But that's what the First Circuit held, and that's why in the Cortez Ramos district court decision, they had to dismiss it without prejudice. And this little footnote 8, the defendant requests for various reasons that said dismissal be made with prejudice. However, as the First Circuit stated, plaintiff could allege registration in a new action. So one of my issues with the court's decision, when the court dismissed the case when the court dismissed the complaint, and when the court dismissed the cross complaints, the counterclaims, it doesn't say that they're dismissed with prejudice or without prejudice, and I think that's a bit of poor opinion writing on the part of Judge Burroughs. You're going to say, well, gee, John, what basis do you have to criticize Judge Burroughs? You're not a judge. Well, that's correct. But you tell me if this case was dismissed with prejudice or without prejudice. You're going to say, well, I don't know. And again, and that's my point. I don't know either. And Chile doesn't know. And the defendants don't know. And so it's going to leave everybody in a state of confusion about whether or not Chile can just refile this. Now, I am not recommending that Chile refiles it. Chile has a loser of a case. This case was doomed to go nowhere and fast, and I'm surprised that it stuck around as long as it did. I think part of the reason why it stuck around as long as it did was because of the way that Wish, the attorney for Kate, who, by the way, despite anything that Kate may have said, remained Kate's attorney throughout the entire case. I think a lot of it had to do with the way that he frivolously wasted, allegedly, some $50,000 to $60,000 worth of client money right up at the beginning and got fuck all accomplished. And his motion was trash. His motion to dismiss was trash. And the only thing that saved it was that Chile's complaints were so much worse trash that the judge was like, well, if I'm dismissing it against Abrams, whose attorney wrote a much better motion to dismiss, and if I'm dismissing it against Google, then I might as well dismiss it against Kate for the exact same reasons, simply because, well, she could have alleged them and didn't. So that's really the takeaway from this case. It could get refiled as far as I'm concerned because of the holding in the First Circuit Court of Appeals case, Cortez Ramos versus Martin Morales, this case right here, 956 F 3rd 36, where the First Circuit said that you can fix it just by refiling. So that's the end on that case. The next issue, there's two things. I'm going to take them slightly out of order. The first one, this is DeCastro versus Las Vegas Metropolitan Police Department, and some of the defendants have answered. These are the officer defendants. I don't believe the state of Nevada has joined in on this. I don't believe they have. So the state of Nevada will probably have its own attorney, which is going to be really fun for Chili, because that attorney probably isn't going to fuck around and just file a 12b6 motion to dismiss and basically say, fuck you and fuck off. And that's all they really have to say. Because Chili has no cause of action against the state of Nevada, despite him writing it to appear as though he did. He has zero cause of action against the state of Nevada. Basically, his cause of action against, basically what he's alleging is that the state of Nevada has statutes that allow for police practices to happen and for police departments to set up policies and procedures. And that would be too close to the court intervening in political matters. The court isn't there to write or rewrite statutes, unless the statute basically said to go F with Chili and do it on the basis of his skin color or something like that. The court isn't going to get involved, and Nevada is going to be out of there super fast. So anyway, the big takeaway on this, and again, I'm just going to cut to the chase, is that they deny everything. They deny literally everything, including but not limited to the excessive force cause of action. I think it was this one that was the excessive force, or maybe it was this one that was the excessive force. I don't remember, but all of them they deny. So Chili's bemused wonderment when he thought that the defendants weren't going to contest his allegations of excessive force. Well, he just didn't wait for the right pleading. Like I said, he had to wait for the answer, and here's the answer, and they just denied everything. So congratulations, Chili, you win nothing. And then finally, last and certainly not the least, is the defendant Las Vegas Metropolitan Police Department's motion to stay. It is a well-written motion to stay. It has every chance of success on the merits. I don't know that Chili's going to be able to do it. I do think it's interesting that that they're filing the motion to stay at this point instead of trying to get rid of it at summary judgment. That is a bit of a strategic issue where the court can, or where an attorney might decide that it would save more money to just stay the action and then let it play out in criminal court. And if Chili's convicted in criminal court, well, then there's just really not a whole lot Chili will be able to do moving forward on this cause of action. That will pretty much kill just about every cause of action he has alleged in here. So that's where we're at on that. Some people were, at least in my Discord, were mentioning the fact of the Keating factors, I think it was, or was it the Heck standard? It wasn't Heck. I thought it was Keating. Yeah, Keating. It was the Keating factors. So the argument that that the state wants to stay this to help Chili preserve his Fifth Amendment rights, that's probably the weakest argument. It's really Younger and Heck are going to be the two good arguments. The two arguments that the court's really going to rely on. Chili always has the option to waive his Fifth Amendment rights if Chili so desires. And so the state or the Las Vegas Metropolitan Police Department can't assert Chili's Fifth Amendment rights for him. Only Chili and or Chili's attorney can assert those rights. Shoot the chicken? How about no, cheeky monkey? That chicken produces delicious eggs, and I would much rather have that chicken be happy and healthy than you. Finally, very, very finally, let's see. We're going to look at one other thing. This is Hibble versus the 6th Judicial District Court of Nevada. This is a United States Supreme Court case that was decided in 2004. What happened in Hibble, just for me to give you a synopsis, is that there was, I believe, a call about domestic violence, and the police responded, and they see Hibble driving away from the scene where the police were headed to, and they believe that Hibble was the perpetrator that they were going to investigate on the domestic violence incident. And I could have these facts wrong somewhat or even in their entirety, and it doesn't change the fact that the police were found to have reasonable suspicion that he was in fact the person that they were looking for. So they pulled him over based on that reasonable suspicion, and they demanded he identify himself. Now, Nevada, the state of Nevada, has a statute that requires you to ID if the police reasonably suspect you of having committed a crime, i.e., if the police have reasonable suspicion. Now, in the grand scheme of levels of proof, reasonable suspicion is as close to no no proof at all of anything that you can get. Remember that reasonable suspicion means that the police can articulate facts that lead a reasonable person to believe that crime is afoot. What kind of crime? Who knows? Who cares? Doesn't matter. But to reasonably believe that crime is afoot, and to reasonably believe that you are the guy who is about to commit, i.e., haven't done it yet, but you might in the future commit a crime. So you're about to commit, or you have previously committed a crime. It is an incredibly low bar. But the court in Hibble said basically that reasonableness is the touchstone of the Fourth Amendment. As long as the state of Nevada is tying the right to, or the obligation, I should say, to identify yourself to that reasonable suspicion standard, then there's a perfectly valid statute. The state of Nevada can have that statute. They can enforce that statute, and there you go. The court also addressed the Fifth Amendment right against self-incrimination was also raised in this case in Hibble, and the court said basically that they don't know of any situation where the Fifth Amendment would be applicable. Your right against self-incrimination would be applicable to your name and address and things like that, and that maybe, depending on the facts, maybe you could assert the Fifth, but the Supreme Court of the United States said that in Hibble, no, it was not a Fifth Amendment violation, and the court doesn't know of any circumstances where it would be a Fifth Amendment violation. They can't rule it out, but they don't know of any situation where it would be. So what do we know from Hibble? We know from Hibble that it is a standard much lower than probable cause. Because remember, probable cause means that the cop reasonably believes that you committed a crime, a specific crime. Not may be about to commit a crime, but that you have committed an identifiable crime. So it's a probable cause is a low standard of proof, but it is a higher standard of proof than reasonable suspicion. So if a cop can get if a state can have a statute that requires you to identify with reasonable suspicion, then a state could also have a statute that required you to identify with probable cause, etc. And if the cop has probable cause, but the statute only requires reasonable suspicion, well, obviously that gives the officer enough, because if you have probable cause, then you have reasonable suspicion. So Chile asserting that the cops require probable cause to identify you is completely wrong. In addition, every state that I am aware of has a requirement that you identify yourself with your driver's license to the police if you're pulled over. And pulled over can mean one of two things. It can either mean the police have at least reasonable suspicion that you've committed a crime or a traffic infraction, or it means that they've stopped you for, or they are engaging with you under the community caretaking function. I did a video recently covering a community caretaking stop in Illinois that Freeman was lying his ass off about. And I went through the court, at least the Court of Illinois' analysis of why an officer can, in fact, identify you using the statute that requires you to present ID upon demand if you have been driving a vehicle for a community caretaking stop. The same logic would obviously apply if you've been pulled over for reasonable suspicion that you've committed some sort of a traffic infraction or crime. So any assertion that Chile makes that the police have to have probable cause to stop you, he would really have to qualify that with identifying what state and what statute he's talking about. Because even in, like, for example, Texas, you don't have to identify unless you've been arrested. Unless you've been driving a car, in which case you have to identify if you've been stopped by police. So there's two statutes with two different standards, and it seems like everybody who gets pulled over in Texas only remembers the standard for a general stop, which would require you to only identify upon being arrested. And they never seem to remember the transportation code standard where you have to present ID on demand. So that concludes my my lesson for today. I'll go over the comments since there aren't that many. We're going to do this. And if you do have comments, now would be the time to put them into the, or questions, now would be the time to ask them. And yes, I am alive. I am insanely busy right now. I have 2 construction cases that I'm working on that are both massively discovery intense, and I have all sorts of other cases going on as well. I'm prepping for a trial in a case. I mean, I am stupid busy, and I probably shouldn't be doing this video. I probably should be doing discovery responses or something like that, but here we are. Hi, Michelle. Nice to see you. Good morning to you too, Scooters. Well, I'm sorry to keep you waiting, Bobby. Praise the Lord and pass the soda crackers. Good morning. Yay, Mervin is Cox. Yes, everybody loves my Cox. Howdy. Where you been, my guy? I have been mostly at my office. Very little court time. Although I did have a criminal hearing up in Calaveras County last week, so that was fun. That was like 10 seconds of wave time, and we're not going to enter a plea yet. Hi, Merb. Love your updates. All the best from Great Britain. Well, all the best to you out there, Dozy Mare. One thing I do love watching YouTube channels from Great Britain. I love their man. Those guys out there, they go ham on their ponds. They love their koi ponds, and I absolutely love watching them go ham on their koi ponds. So yeah, Josh's motion had with prejudice. That doesn't matter. Cyan Rose. Google's also had with prejudice. That they asked for it. I don't believe it was granted with prejudice, and if it was, that's appealable error. So there you go. Yes, my cock does always get in the way of a lot of things in my life. Yes, it tends to cause me to do stupid things. Yes, Google's motion did as well. Yes, it did. That is information, but that is entirely irrelevant information. Great hot morning, Merb. Stay cool, I'm guessing. I plan on working in my fish room, which is fairly hot. I leave the door open and to the fish room to keep the humidity down. I have a dedicated air conditioner for that room that has a dehumidifier function in it, but that's a lot of energy, and might as well just leave the door open and run a fan. Muzzle your cock. I believe it's called a condom, sir. Too many frivolous submissions ought to be criminal. No, the court has other methods of dealing with frivolous submissions. If they are in fact frivolous, the court can sanction for frivolous motions. And so there you go. He'll learn the real meaning of excessive force when he makes it to the rape cage. Now, I always have a problem with people who talk like this. We all understand that rape is a crime, and we all understand that it should not happen to people, and yet for some reason, you think that Chili did something so wrong that he should get raped in prison. You're celebrating it. I personally hope Chili does not get raped in prison. I don't think he'll go to prison on a misdemeanor. So there's that. And, maybe it's just your kink, and maybe I shouldn't be kink shaming you. Maybe it's your fantasy to be raped in prison. But you really shouldn't wish that on people. It's a terrible thing. It's a terrible thing to get raped, and rape is not a lawful punishment in the United States. No one gets sentenced to be raped, and the police, the prison wardens and things like that should take every step to ensure people aren't getting raped in prison. I hate that Burroughs was so lazy as to not specify prejudice or not. Chili himself said he will be vexatious. I don't think that Burroughs has an option. Chili can fix this now that he has a registered copyright. He can fix this by filing. So if he goes back in and files again for specifying what videos violated that specific copyright, then he would have an actual case. I almost said meritorious. At least something that could arguably be meritorious. Now I don't know how a court would come down. I would suspect that, having watched Kate's video, that I would suspect fair use would apply, but who knows, right? Shoot the chicken. I addressed that. Lol. Was just asking the hubby why you had not gone live. Well, here I am. Will Google go after Chili for legal fees? I don't imagine Kate or Josh, with their similarly bad counterclaims, have much leg to stand on. I don't think Google will give two shits about trying to chase down legal fees from Chili. Oh, and speaking of Google punishing Chili, there was some dickhead in here in my comment section who kept going on and 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 on about how Chili was going to lose his channel because once this case was done. And I would like to say to that person who I have disinvited from commenting in my chat that neener, you're a fucking idiot, and Chili still has his channel. So how does it feel to be so wrong? And the next time you accuse Chili of being stupid and wrong, sir or madam, whoever you were, imagine the gall, the cojones it takes to do that when you were wrong yourself. Merb is having a cock fight. I prefer to think of it as a cock struggle snuggle. I doubt it. You're welcome. I do too. That's why I included Can't Google. I was just wondering what his opinion was. Well, I probably gave it to you then. Chili is crazy. Probably not. Chili needs a real job, and he definitely needs to stop lying. Chili should probably stop lying, although I don't know if Chili is lying or if he just misunderstands. Because Chili is not, to me, to my understanding, let me rephrase that. In my opinion, Chili does not appear to be grounded in reality. Chili's understanding of what reality is does not appear to comport with what reality actually is. So is that he's lying, or is it that he just completely misunderstands? Maybe he has some learning difficulties. Maybe he has some mental issues that prevent him from understanding. I don't know. Random pedestrian cavity searches. So you're the rape cage guy. So I'm getting the idea that that's your personal kink, and I'm not going to kink shame you. So if you want random pedestrian cavity searches, love the chickens. I do too. Hi to Peanut, apparently. I know you can't squeeze blood from a turnip, but you can squeeze the turnip anyway as a lesson to other turnips not to file frivolous lawsuits. Well, Chili would neither know nor care that he was being squeezed. Thank you, the Coop. I intend to be entertaining and informative. As always, thanks for the education and laughs. Happy chicken morning. Happy chicken morning to you too. Hello from a good citizen. Okay. What's leave to renew? Leave to renew. That means that if for whatever reason the motion to dismiss gets set aside, Google can bring its motion to transfer again. The court hasn't ruled on it, so the court hasn't denied it. It's just moot. Like the court's like, this is moot, so I'm denying it, but I'm really only denying it because it's moot. So if for whatever reason this case gets undismissed, you can bring your motion again, or you could renew your motion, which means you don't have to like retype it and everything. And then I will rule on the renewed motion. The court said Chili dismissed the case. The court said Chili dismissed the case with leave to renew. The court said Chili dismissed the case with leave to renew. The court said, I don't believe so. I don't think the court said that. So maybe I missed something. I don't know. If I'm wrong, I apologize. Hello. It's been a while. I've been at the beach. Well, I hope you're rocking a nice tan and not a sunburn. Sorry, meant the court said it dismissed Chili's case with it dismissed it denied all right, let me share this tab. Let's do this. So this is from the court's ruling on defendants' motions to dismiss. Google's motion to transfer at ECF number 121 is denied as moot with leave to renew if necessary. So it's just the motion to transfer that was denied as moot, and that is what that Google can renew if they need to. Merv needs an assistant. Yes, I do. Was he arrested? I've been out of it. Was who arrested? I was not, if that's who you're talking about. The rooster wants to be seen and heard. Yes, he probably does. Lowell Roosters. Your rooster is stealing the show in the background. That's pretty much all the time. Great to see you too, Devin. Lowell, don't forget, Chili's the one who yelled, "Where is the danger?" to police arresting a DUI driver. Unpopular opinion. I don't think it should be illegal to drink and drive. It is already. I think it should be illegal to cause injury to someone while you're drunk driving. But I don't like all these preemptive laws. These laws that are there to attempt to mitigate risk, like the law requiring you to have a seatbelt on. I think we have way too many laws, and laws like that like try to pre-criminalize things. Because there are lots of people who drive drunk every day and don't injure anyone. Now, The odds, I understand the odds increase of them injuring people because they're drunk. I understand that. But if they don't actually injure anybody, then I don't particularly see why we need to criminalize it. And there you go. Merb, cutting right to the facts, straight shooting today. Well, yeah, it's going to get hot. I don't want to be out here for 3 hours. Are Chili's original defamation claims permanently gone since he accidentally abandoned them with the amended complaint? Maybe. The court didn't rule on that. And that would be interesting to find out. But the court was... what was weird about the Massachusetts court was that a lot of times, in my experience, the judge will assign the case to a magistrate for basically everything, and the magistrate will hear everything and then make a recommendation to the judge, and the judge will issue the order based on the recommendation the magistrate judge made. That didn't happen in this case, and that means that the judge, who is presumably really busy. Oh, the difference between a magistrate and a judge, in case you don't know, in order to become a judge, you have to be approved by Congress, and you have to go through all the steps. And there are not a lot of judges compared to the number of cases out there. So in order to kind of like take some of that work off the judges, not to say judges are lazy, but they have a lot of cases. A lot of courts, I thought all courts, but I guess a lot of courts hire magistrates who are qualified, and they are in all aspects judges. They can hear evidence and do things like that, but then they just make recommendations to the judge, and the judge will, generally speaking, just rubber stamp what the magistrate judge said to do, with the caveat of if there's any blatant mistake of law, then that the judge catches, then the judge will typically send that back. But like issues of fact, findings of fact, the judge will usually leave that to the magistrate. Are you out of your mind? Yes. I don't know. Like, I don't know. Am I out of my mind about what? The term rape cage is chilly for jail cell. When they wrote rape cage, they were mocking Chili, not wishing that he be raped. Fair point. So my apologies to this guy, Real Cygnus. So, mea culpa. I definitely see your point. Don't necessarily agree, but that's okay. All right, yeah, that's reasonable. Should I ask again? I'm going to go with no, because apparently you've asked twice and have been so cryptic that I don't understand what the fuck you're talking about. So no, you should not. Thanks for the stream, Mr. 34th Street. 34th Street represent. 34th Street represent. Drunk drivers should be taken off the road. That's your opinion, sir, and you're welcome to it. I don't believe that people should drive drunk. But I also don't think that people should drive distracted. I don't think that people should drive with cell phones. I don't think that people should drive with kids in the backseat making noise and causing commotions. However, those things happen, and they may or may not be criminalized in your state, but I don't think they should be. Just because you shouldn't do something doesn't mean it should be a crime. So yeah, how about that? I don't think that everything you should or shouldn't do should be a crime. So anyway, that's it. That's the end of the stream. Thanks for watching, and have a great day.